The landscape of U.S. immigration is undergoing a significant transformation. Get ready, because big changes are coming to the U.S. immigration system, impacting procedures and requirements for many. These changes will particularly affect those seeking to establish their lives here permanently. Mark your calendars because on August 1, 2025, these new policies will officially take effect. This is a crucial date to remember if you or your loved ones are involved in the immigration process. These changes will be especially impactful for families applying for green cards, those hoping to unite with their loved ones in the United States. The process is about to become more complex, requiring careful attention to detail. USCIS, the United States Citizenship and Immigration Services, is rolling out stricter rules and guidelines that will govern how applications are processed and evaluated. These changes reflect a broader effort to enhance the integrity of the immigration system. The focus of these new rules is primarily on marriage-based and family-based green card applications, which are common pathways to legal permanent residency. These categories will face increased scrutiny and more stringent requirements. These changes won't just affect new applications, they will also impact both new and pending cases, meaning that even if you've already started the process, you need to be aware of the updated regulations. It's essential to review your application in light of these new rules. The new policy means that an approved I-130 petition, which is often the first step in sponsoring a family member, no longer offers any legal status or protection from removal on its own. It's a significant shift, emphasizing that further steps are necessary to secure legal residency and avoid potential deportation. In light of these changes, every step must be perfect, meticulously documented and fully compliant with the new regulations. Accuracy and thoroughness are more critical than ever. If applications are incomplete, inaccurate, or fail to meet the stricter requirements, families risk denial and even deportation. The stakes are high, making it essential to approach the process with utmost care. USCIS officers now have more power and discretion in evaluating applications, allowing them to delve deeper into the details and make more nuanced judgments. They are empowered to scrutinize applications for fraud with greater intensity, looking for inconsistencies, misrepresentations, or any indication of fraudulent intent. This is especially true for those with previous marriage-based petitions, as these cases will be subject to heightened scrutiny to ensure the legitimacy of the relationships. To support these enhanced enforcement efforts, the government is dedicating more resources to USCIS, providing the agency with additional tools and personnel. This increased investment aims to crack down on marriage fraud and other forms of immigration fraud, sending a clear message that such activities will not be tolerated. All of this is making the process more rigorous, demanding greater attention to detail and adherence to complex regulations. Navigating the system will require a deeper understanding of the rules. As a result, the consequences of mistakes are more severe, with even minor errors potentially leading to significant delays, denials, or even legal repercussions. Furthermore, mandatory interviews are becoming the norm for many applicants, providing USCIS officers with an opportunity to assess the credibility of the application and the genuineness of the relationship. With increased scrutiny and stricter enforcement, the margin for error is shrinking, requiring applicants to be exceptionally diligent and well-prepared. For honest families who are simply trying to navigate the legal pathways to immigration, the journey just got a lot tougher, requiring more effort, resources, and understanding of the system. Therefore, understanding these new rules is essential for anyone seeking a green card or other immigration benefit, ensuring that they are fully compliant with the latest requirements. Staying informed and seeking expert guidance is crucial to avoid legal jeopardy and ensure a smooth and successful immigration process. Despite these challenges, the path to the American dream remains open, but it now requires a more strategic and informed approach. Securing your future in the U.S. now demands more diligence and preparation than ever before, emphasizing the importance of seeking professional legal advice and staying up to date on the latest immigration policies. There's a common misconception that we need to address directly. Many people mistakenly believe that simply having an approved I-130 petition automatically grants them safety from deportation. They feel a sense of relief thinking they're protected. But the new rules and recent policy changes make it abundantly clear. An approved I-130 by itself does not provide immunity from deportation proceedings. It's crucial to understand this distinction. Approval of a family-based petition, such as the I-130, is indeed a significant step, but it's just the very first step in a much longer and more complex immigration process. Think of it as the starting point of a journey. It's vital to remember that an approved I-130 on its own grants absolutely no legal status or protection whatsoever if you are currently residing in the U.S. without authorization. You remain in a vulnerable position until you successfully navigate and complete the entire immigration process, which involves several crucial steps and detailed paperwork, including adjusting your status within the United States by filing Form 1-485, the application to register permanent residence or adjust status, or, alternatively, pursuing consular processing through a U.S. embassy or consulate located abroad. You unfortunately remain vulnerable to potential removal proceedings and deportation from the country. The risk is very real. This is an especially critical point to understand for those individuals who have overstayed the validity period of their visas. Simply having an approved I-130 petition will not, in any way, shield or protect you from immigration enforcement actions. The updated policy aims to close a significant loophole, a loophole that, in the past, inadvertently gave many families a false and ultimately misleading sense of security regarding their immigration status. Even in situations where there is a U.S. citizen spouse involved, and an I-130 petition has been successfully approved, the fact of being unlawfully present in the United States can still unfortunately lead to deportation proceedings and a removal order. The entire process of obtaining a green card and achieving permanent residency is best understood as a series of complex legal hurdles that must be cleared. Clearing just one of those hurdles, such as the I-130 approval, does not in any way guarantee success in clearing the subsequent hurdles. Therefore, families must now approach each and every step of the immigration process with meticulous precision, careful planning, and a heightened sense of awareness. The stakes involved are undeniably higher than ever before, and the margin for error has essentially vanished. There is very little room for mistakes. It is absolutely essential to handle every single detail of your immigration case correctly and with the utmost care, or you run the very real risk of losing your chance at securing a future for yourself and your family in the United States. In the ever-evolving landscape of immigration law, changes can often bring uncertainty and even alarm. It's crucial to stay informed and understand how these shifts might affect your immigration journey. One of the most alarming changes is USCIS's expanded authority to issue a Notice to Appear, NTA. This expansion represents a significant shift in how the agency operates and who might be subject to deportation proceedings. An NTA marks the commencement of deportation proceedings, a formal process that could lead to removal from the United States. It's a serious matter that requires immediate attention and legal counsel. What's particularly concerning is that USCIS can now issue an NTA even after approving your family-based petition. This creates a situation where individuals who believed they were on a path to legal residency suddenly find themselves facing deportation. Consider this: the same agency that approves your marriage, acknowledging the legitimacy of your relationship and your eligibility for immigration benefits, can also initiate your removal from the country. This dual role creates a precarious situation for many immigrants. This can happen if you're found removable for reasons like overstaying a visa, even if it was unintentional or due to circumstances beyond your control, or engaging in unauthorized work, even if it was to support your family while awaiting work authorization. For example, imagine a tourist who marries a U.S. citizen, genuinely and in good faith, with the intention of building a life together. If that individual then gets I-130 approval, signifying that their marriage is considered valid by USCIS, they could still receive an NTA and be placed in deportation proceedings for the initial act of overstaying their tourist visa. This unfortunate scenario means families may have to simultaneously fight for a green card, demonstrating the legitimacy of their relationship and their eligibility for residency, and defend against deportation in immigration court, arguing against their removal from the United States. This creates a complex and emotionally taxing legal battle. USCIS is now effectively functioning as both a benefit-granting agency, responsible for approving petitions and applications, and an enforcement agency, tasked with identifying and removing individuals who violate immigration law. This dual role significantly increases the risk for anyone with even minor immigration violations in their past. Any issue, no matter how seemingly minor, in your immigration history can now potentially trigger removal proceedings, placing you on a path towards deportation. While proving a valid family relationship is absolutely necessary for a family-based petition, it's simply not enough to overcome other grounds of inadmissibility, such as prior immigration violations or criminal history. Your entire immigration history, from your initial entry into the United States to any subsequent interactions with immigration authorities, will be under the microscope. The message is clear. There are no safe harbors, no guarantees of approval, until every single requirement is meticulously met and all potential issues are addressed. Therefore, flawless applications, supported by comprehensive documentation and clean records, are more important than ever in today's heightened enforcement environment. In-person interviews are now standard for all marriage-based green card applicants. Waivers for straightforward cases are gone. Every couple must meet with a USCIS officer. These interviews are intense, probing every detail of your relationship to detect fraud. Officers look for inconsistencies and red flags with more power to dig deep. The government has invested millions to combat marriage fraud, making interviews a critical part of the process. Couples must prepare thoroughly, bringing extensive documentation and being ready for tough questions. It's not enough to have a real marriage. You must prove it convincingly under pressure. The burden of proof is on you. Preparation is key. Fraud detection is now front and center. Every family-based petition faces intense scrutiny. Officers are trained to spot any sign of deception, especially in cases with previous marriage petitions or red flags like large age gaps or short courtships. Data analytics and enhanced screening target high-risk cases for deeper investigation. High-profile fraud cases have led to stricter vetting for everyone. A few photos and a marriage certificate are no longer enough. Couples must submit comprehensive evidence, joint finances, leases, insurance, and affidavits, to prove their relationship is real. The goal is to leave no doubt about your marriage's authenticity. Only overwhelming proof will satisfy the new standard. The new rules leave no room for mistakes. Minor errors can mean instant denial, with no second chances. Officers can now deny applications outright for missing documents, typos, or incomplete answers. A forgotten signature or missing translation is enough to derail your case and trigger deportation proceedings. The policy aims to improve efficiency and discourage poorly prepared filings, but it puts enormous pressure on families. Every detail must be perfect, double and triple check everything before submission. For many, hiring an experienced immigration attorney is now a necessity, not a luxury. The stakes are too high for even the smallest oversight. Perfection is the new standard for success. The new rules make understanding immigration terms more important than ever. The I-130 petition starts the process but grants no legal rights. Removal proceedings begin with a notice to appear, NTA, which can be issued even after I-130 approval if you're removable. Immigration fraud, like sham marriages, leads to denial, penalties, and permanent bars. Legal status means having government permission to be in the U.S., a visa, green card, or citizenship. Overstaying a visa puts you out of status, and an approved I-130 doesn't fix that. You only gain legal status after your green card is approved, or you enter with an immigrant visa. Know these terms and what each step means. Understanding the process is your first defense against costly mistakes. Stay informed to protect your family's future. USCIS's mission is to protect the integrity of the immigration system, not to punish genuine families. The new rules target fraud and abuse, aiming to restore public confidence in family-based immigration. Enhanced interviews, document scrutiny, and officer authority are all part of a broader security strategy. Honest families now face a heavier burden of proof and more anxiety over small mistakes. The challenge is balancing strict enforcement with fairness for real families. The system must prevent fraud without making legal residency impossible for those who follow the rules. The path is tougher, but not closed to those who prepare. The new rules demand caution, diligence, and absolute honesty from families seeking green cards. Be thorough, submit more evidence than required, and organize it clearly. Be honest. Never misrepresent facts, and address any complicated history up front. Seek professional legal advice. An experienced attorney can help you avoid pitfalls and prepare for tough interviews. A green card is more than a document. It's the key to your family's future. The process is harder, but not impossible. Understand the rules, prepare a strong case, and get help when needed. Stay informed and proactive to protect your loved ones. The American dream is still within reach for those who are ready. preparation and knowledge are your best tools for success.